Services will continue. We do not plan to make any tier decisions up or down until we've sorted through this. Again, exceptions being placed instances where there is a crisis or there is an emergency.
We have a contingency plan. I would like to remind you exactly where we are with this. At 3:30 Friday afternoon, we got notice from the appellate court of this decision. And we've worked through the weekend, and I was on the road yesterday. My understanding is that folks worked quite a lot yesterday. And we had started because those particular persons have also gone to court. We have a contingency plan that is based on the potential of getting a injunction in the next few days. We don't know how the judge is going to react, what the judge is going to do, but we have a contingency plan for those people. I believe it's 2,000 to 3,000 people that did not get a hearing for what we call feel is just cause. If we are wrong, we will be ready to work contacting people and going through our area offices to our providers and making those corrections. And that's the unfortunate aspect of the situation where we get into a lot of litigation. People who litigate should be pleased that if we are found to be in error. Unfortunately, that means you guys are going to have to go back and change it. So the general answer is yes. The timing is uncertain. It'll be a day or two, maybe before the end of this month. But we have a plan that could stop that. And our legal team is still in Tallahassee working on this today, and we'll have a finite decision on that. But it falls under the idea that we're going to stop at this point. We do have legal considerations.
So that means that the new authorizations that were issued with changes based on them not having the hearing effective September 1st, which is next Tuesday, are going to be null and void, so the services are supposed to stay in place?
That's one of the many complicating things that we're working moment to moment on. I really have to be very honest with you and tell you, maybe yes, maybe no. That's a whole other court and a whole other judge and a whole other case. And I'm reluctant to speak for Mr. DeBeaughrine's attorney, but I can probably call them at the break and find out how they have viewed this. But we do have a contingency plan based on that hearing. So it's a very complicated legal environment in which we are. I want to make sure everybody understands. We're talking about two different legal cases here. One case has to do with whether or not persons were denied due process. We believe we're right. We have taken appropriate steps to reduce their plans, and we've given outside 45 days for everybody to adjust. And that judge had promised us a decision before the end of July. And that decision hasn't come. Friday at 2:30 we got a decision on a whole other group of people for whom we had gotten due process. We had assigned tiers according to our process, and there are simple elements of that that the three judges said need to be tweaked, and we're working on those tweaks. So we have a whole legal team in Tallahassee looking at all of these possible episodes, and they will call Jim and I and let us know just as soon as they've gone through all these permutations. But that's always been a possibility that we went forward, and that was the basis of their lawsuit. And if they were to prevail, those would be null and void. We would stop right there. So I will answer. I'll get back to you.
At this point in time, we're not going to move forward with September 1. unless through some miracle the court were to intervene prior to that, but that's not going to happen. I'm just going to need to ask you guys to be patient with this. I'm not sure the court took into account that we were, in essence, facing a September 1 deadline. And they gave us the information Friday, just a few days beforehand. But if the eligibility for the new tier, for the tier that you're going to be assigned to, is in question because you've got an appeal pending, we're going to hold that until we get more clarification from the courts. It's just going to take, we're hoping to have some additional information in terms of what our response is going to be sometime this week. I'm just not in a position to tell you specifically what exactly is going to happen this time because we haven't decided. If a provider has a valid service authorization, it will be honored. That's just.
The September 1's going to do something. So if you're saying they're not going to take those reductions into account, then there's a problem with the authorization because the September 1's already been put in place to reduce everything based on.
We want to move beyond this because this is really one of these things where the devil's in the details. But one of the things, in the case of these 3,000 people who've taken legal action that they're fully entitled to take, and we have gone to court, they have requested an injunction. We are prepared and have been prepared to pull back those service authorizations for some time. But it looks like it will probably be an extraordinary effort. I mean, what you're describing is true. There will be, in the next few days, some contact from my office pulling those back as we solidify our posture here. But a lot of discussion and a lot of consideration from attorneys goes into every step that we make. We're not going to just knee-jerk. We believe that that's the right thing to do. We'll get it started today, tomorrow,